Understanding labor laws and overtime requirements can be confusing, but employers must classify their employees correctly or risk costly compliance violations. In this presentation, we will discuss the difference between salary-exempt and non-exempt status employees. The information contained here has been prepared by Civitas Strategies and is not intended to constitute legal, tax, or financial advice. The Civitas Strategies team has used reasonable efforts in collecting, preparing, and providing this information, but does not guarantee its accuracy, completeness, adequacy, or currency. The publication and distribution of this information are not intended to create, and receipt does not constitute, an attorney-client, or any other advisory relationship. Reproduction of this information is expressly prohibited. Only non-commercial uses of this work are permitted. In today's conversation, we will discuss the parameters that define exempt and non-exempt employees, go over the different types of exceptions that may apply to individuals working in childcare, and look at the Fair Labor Standards Act overtime requirements. As a business owner, you've likely heard the terms exempt and non-exempt in relation to your employees or hiring practices. These classifications are outlined in the Fair Labor Standards Act, or FLSA. Signed into law in 1938, the FLSA establishes minimum wage, overtime pay eligibility, youth employment guidelines, and record-keeping standards for both the private and public sectors. Essentially, the FLSA outlines how work hours are documented and how employees should be paid. While the FLSA has evolved over the years, the law continues to dictate how the modern workforce is regulated, including child care and small businesses. Understanding labor laws and overtime requirements can be confusing, but employers must classify their employees correctly or risk costly compliance violations. The term non-exempt refers to workers who are covered by FLSA guidelines and requirements. In other words, they are not exempt from the law. The term exempt refers to workers who qualify for exemption from the law. A common misconception is that employees who are paid a salary rather than an hourly wage are exempt from overtime and other requirements. But the legal reality is more complex and requires a determination of the employee's status under the FLSA. By assessing your employee's positions, you can better understand your obligations as an employer. Another misconception is that the employer or employee gets to choose their status. It isn't a choice, but rather about how they fit within the laws around employee classification. To understand how an employee should be classified, there are two criteria. One is a salary amount threshold, and the other is the kind of work they perform. Employees exempt from the FLSA must be paid a salary above a certain level and must have specific duties. The table shown here from the U.S. Department of Labor shows how they describe the criteria. The main difference between these worker classifications is that employers are not required to pay overtime to properly classified exempt workers. They must receive their full salary regardless of the number of days or hours worked. Since they are not paid according to the hours worked, if salary-exempt employees work more than 40 hours, there is no requirement to pay overtime. Exempt employees are also excluded from other FLSA protections afforded to those who are non-exempt. As stated in the FLSA, in most instances, an employee that has a salary basis of no less than $684 per week or $35,568 annually is classified as exempt. However, for teachers, the threshold is lower, $455 a week or $23,660 a year. While overtime pay is not required for these workers, they can be given additional compensation in the form of bonuses or stipends. In addition to their salary level, there are also certain exempt professions, such as administrative, executive, outside sales, etc. If an employee performs the duties related to these types of positions, they may also be classified as exempt. More on those specific positions and duties will be discussed later. On the other hand, employees who are classified as non-exempt are required under the FLSA to receive overtime for any hours worked over 40. These employees are usually paid an hourly wage or earn a salary that's less than the minimum amount required. Since they are not exempt from the FLSA, non-exempt employees who work more than 40 hours in a week must be paid an overtime rate of 1.5 times their regular pay. Most non-exempt employees must be paid at least the federal minimum wage, but many states or jurisdictions with higher costs of living have set minimum wages above the federal base. If a non-exempt employee isn't paid by the hour but is entitled to overtime pay, their hourly rate is calculated by dividing the total compensation earned by the total hours worked, not including vacation holidays or sick days used. In 1972, the FLSA was amended specifically to extend the coverage of the law to preschools and child care programs. This is true for both public and private institutions, and those operated on both for-profit and non-profit models. All public school system staff, including those in child care, are considered exempt. The government outlines covered early education enterprises as ones that provide custodial, educational, or developmental services to preschool-age children to prepare them to enter elementary school grades. Family child care providers or home-based providers are not considered covered under this amendment unless they have employees. If a child care business's employees are not otherwise exempt due to their salary level or assigned duties, the employer is required to meet FLSA guidelines. This includes establishing a set workweek for pay purposes, maintaining payroll records, paying at least the federal minimum wage, and paying the required overtime rate for more than 40 hours worked. In addition, independent contractors, or those paid via 1099, are not covered by the FLSA. Therefore, they are not entitled to the wage and overtime pay benefits outlined in the law. As noted, there are two criteria to help determine whether your employee will be exempt from FLSA. In addition to the set salary threshold, there are also standards related to the position they hold, the type of jobs and duties they perform, and their level of authority or autonomy to make decisions. Exempted positions and duties may include an executive or administrator who supervises more than 2 employees, that management is the primary duty of the position, and has genuine input on the job status of others, such as hiring or firing. Or, a learned professional who is in a field of science or learning, with advanced knowledge acquired with prolonged study and education. According to labor laws, an exempt executive position is one who oversees a unit or department and who regularly directs the work of 2 or more employees. To qualify, this employee's work duties must fall into this area at least half the time. Management duties such as interviewing, directing work, evaluating performance, or initiating disciplinary actions count as exempt activities. In contrast, routine clerical duties like billing, filing, and bookkeeping do not. Practically speaking, in a larger childcare program, this likely means that the director or program administrator is exempt, since the majority of their duties include those classified as executive or managerial in relation to the rest of the staff. If you have an assistant director, they may fall into a gray area, as they may spend more than 50% of their time with children and/or performing the same duties as other members of the staff. The key takeaway here is understanding that management titles alone do not determine exemption status. The exemption criteria that is the vaguest and most commonly misapplied has to do with an employee that performs administrative duties. An exempt administrative employee regularly exercises discretion and independent judgment, devotes more than half their time to performing specialized or technical work that requires special training, experience, or knowledge, and earns at least $250 a week on a salary basis. Overall, the exempt administrative employee's discretion and independent judgment must relate to business operations or policies that involve substantial matters of consequence to the business customers or other employees. Again, because job titles are not a reliable way to determine exemption, this is a place where employees are often misclassified. In certain instances, an employee that performs the work of a teacher could be considered exempt from FLSA requirements, as there is an exception for learned professionals. For an employee in a teacher position to qualify as a professional in this capacity, their main responsibilities must involve instructing, tutoring, or lecturing children. If their main role is to ensure the well-being of the children and meet their physical and emotional needs, they will not be exempt based on their role. Under FLSA, an exempt employee must perform administrative or professional duties at least 50% of the time. It is difficult for child care providers, especially those who work with the youngest children, to meet that percentage. A child care provider will qualify as an exempt employee under the learned professional exception to the FLSA if 3 requirements are met. 1. The teacher must be paid on a salary basis not less than $455 a week, or $23,660 a year. 2. The teacher's primary duties must be lesson instruction or work that imparts knowledge to the children in their care, rather than activities that meet their physical or emotional needs. And 3. The job performed by the teacher must require advanced knowledge in the field of science or learning, which is customarily acquired by a prolonged course of specialized intellectual instruction. This last requirement indicates that the teaching position in question must require at a minimum a 4-year degree from an accredited college or university in early childhood education, elementary education, or a related field. If a program employs both teachers and caregivers who meet the minimum education requirements, as well as those who do not, it may be necessary to establish two separate job titles and job descriptions in order to preserve the exempt status of the more highly educated teachers and caregivers. In addition to the learned professional exemption, FLSA regulations also include a specific teacher's exemption. This exception has much more lax educational requirements than the learned professional exception. In fact, according to a Department of Labor opinion letter published in October 2005, Compliance Assistance, or website dol.gov, there is no minimum educational or academic degree requirements for bona fide teaching professionals in educational establishments. Additionally, unlike the learned professional exemption, the teacher exemption has no minimum salary requirement. Unfortunately, while it sounds like this language makes an ideal FLSA exception for childcare providers, the teacher's exemption has one added requirement, which makes it inapplicable to most childcare providers. According to the language, in order to qualify for the exemption, the provider must be employed in an educational establishment. The regulatory definitions mean that unless a child care business is certified by their state Department of Education as a preschool or kindergarten, the teacher exemption does not apply to their employees. As we've outlined, the FLSA defines mandatory overtime as work time above and beyond a 40-hour, pre-scheduled workweek. A non-exempt employee who works over 40 hours in the week must receive overtime compensation, or pay, calculated at 1.5 times their normal wage. For the purposes of FLSA, employers that authorize short breaks or rest periods must count them as hours worked. Short rest periods, usually around 20 minutes, are common and customarily paid as work time. Meal periods of 30 minutes or more are generally not compensated, as long as the employee is completely relieved from job duties for that entire time. If an employee watches over napping children while they eat lunch, for example, they are not considered relieved. Similarly, attendance at trainings, meetings, or professional development must be counted as work time unless all of the following criteria are met. It occurs outside normally scheduled hours of work. It is completely voluntary. It is not job-related, unless the employee attends an independent school or college on their own initiative outside work hours, and no other work is performed during the period. Time spent at a training that is required by the state for licensing purposes is work time that employees must be compensated for. These are some examples of overtime scenarios. Andrew's mother arrived 1 hour late to pick him up, and his caregiver, Miss Alicia, has already reached her 40 hours for the week. Since Miss Alicia was required to stay until the parent arrived, 1 hour of overtime could be paid in this situation. Miss Lori, the administrator of the program, has scheduled meetings with parents of 5:30 on Monday, Tuesday, and Wednesday of this week. The program closes at 5 p.m., but this is the only time these parents are available. This will go beyond 40 hours for her. If Miss Lori is a salary-exempt employee, she will not be paid extra for this time. All staff members are required to complete mandatory CPR training on Saturday for Uptown University Child Care Center. All the staff have met their 40-hour workweek, so the additional time is counted as overtime. Labor experts and regulators have identified several problems that occur related to child care employees. Chief among these are employers not completely or accurately counting hours worked. For example, employees who are off the clock for a meal or break, but are still required to supervise children, speak with parents, or run a work-related errand. If an employee is performing job duties, they should be recording time for that work week. In addition, employers are scrutinized for requiring employees to stay late, come early, or attend a training on their own time, or for a flat fee, instead of their hourly wage. Other acts that could be considered violations are improperly deducting pay, paying a flat fee for overtime, or paying proper overtime after 80 hours in 2 weeks instead of the stated 40 in 1 week. Childcare business owners should include the status of the position on the actual job description or in the employee handbook, and staff should sign a copy that will be placed in the employee's records. Finally, every employer should remember that exemption rules and labor laws are complicated, and often dependent on specific instances related to your business or your staff positions. In many cases, speaking directly with a qualified compensation consultant or a labor attorney can be helpful to gain clarity on classification, wage, or human resource matters. For more information, visit the Childcare Collaborative of Iowa website or email fmc@midsioux.org.